welcome to the Arbitration Conversation. So in this webisode, we're going to be discussing international investment treaty arbitration, and we have a true leader in that space and an expert in that area. So it's very exciting to have Michael Waibel here. He is a professor of international law at the University of Vienna. He teaches and writes with a focus on international law, international economic law, sovereign debt, and international dispute settlement. He is the general editor of the ICSID reports. So, Michael, thank you so much for taking the time with us today.
Thank you. Delighted to be here, Amy. Thanks for the invitation.
Well, it's because I read your work and I found it really interesting, and I'm excited to have an opportunity to talk to you about some of these issues that you uncovered with your own research. Really great stuff. So to start off, what are some stylized facts about investment arbitrators? And when you think about the sociology of arbitrators and kind of the community of arbitrators, as it were, in the area of investment treaty arbitration, what are some of the stylized facts that you uncovered?
So it's often said that in the community of investment arbitrators has a club-like character. That is, it's very difficult for newcomers to join that relatively exclusive club. And I think that's still that's still the case today, though there has been some diversification of who arbitrators are. But what's really quite striking is that most arbitrators, more than half of all arbitrators in the investment field, are only ever appointed once to a tribunal. So there is no reappointment. At the same time, we have what one could call elite arbitrators who are appointed 20 or more times. If we look at
wow.
Yeah.
How does that happen? I mean, I want to hear more about, yeah, because that's really interesting. How do you become sort of part of these elite arbitrators?
I think that there's quite a bit of uncertainty about how exactly that works. But I guess one important mechanism that is at play is that arbitrators are chosen by the parties, like it is the case for all forms of arbitration. And because the stakes for investment disputes are usually quite high, certainly for the host state, there is, I think, strong incentives for counsel on the investor side, counsel on the host state side, to go with a conservative, in quotation marks, choice as their arbitrator, someone who is tried and tested, someone who has done this before, someone who may hold sway with the other members of the tribunal, because the key is really to get the president to agree with you, at least mostly to agree with you, so that you have a majority on the tribunal.
You know, though, I mean, when I think about this, though, and you think about sort of the status quo, what does that mean for diversity? You know, what are we talking about here when you think about the status quo and these people with experience and kind of the elite arbitrators and kind of the club atmosphere? What does that mean for diversity?
It means for diversity that there is still a long way to go to achieve diverse investment tribunals, and that I think applies to various dimensions of diversity. Traditionally, that is until very recently, there were very few female investment arbitrators. There's now, that has been growing over the last several years, but from a very low base. And still more than 95% of all arbitral appointments to date have been men. There are certain jurisdictions that are very well represented among investment arbitrators, particularly France and the United Kingdom, overrepresented, one might say, and other jurisdictions that are underrepresented, particularly arbitrators from countries that have often faced investment arbitrations, foremost African countries. Arbitrators from African countries have traditionally been underrepresented.
And as kind of digging a little bit deeper and thinking about why it matters. Yeah, so paint the picture for those that, aren't familiar with kind of why it matters and how it works. Give us an example, because I could see definitely why diversity is so important, because you're talking about really important, the stakes are high in a lot of these cases, and especially when we think about developing nations. So maybe do you have an example about how kind of this matters with respect to outcomes and development?
So I think it's really hard to show that in a particular case the tribunal would have decided differently had there been a different member. So instead of, say, a French member of the tribunal, there had been a Kenyan member of the tribunal. So for that reason, it's hard to give a specific example where one can really be sure that that composition of the tribunal had a direct causal impact on the outcome. That said, from the perspective of from the perception of the process, I think the relative lack of diversity among investment tribunals is a real issue and has been for some time.
Well, and yeah, I can see exactly what you mean. That'd be hard to sort of, given a specific example and say it would have turned out differently, but at the same time, perception matters. How has this played into kind of the evolution of investment treaty arbitration and kind of perceptions about the process, do you believe?
So I think there has been growing concern among arbitral institutions such as ICSID and the Permanent Court of Arbitration about this lack of diversity, and they have undertaken laudable steps to address this lack of diversity. But most of the arbitrators are appointed by the parties, are chosen by the parties. So there's only so much that institutions can do. It's really the choices of the parties themselves that, to a very significant extent, determine the composition of arbitral tribunals, and not just the party-appointed arbitrators, but also the presiding arbitrators chosen by common accord of the parties.
Do you have any ideas about how, because yeah, I mean, I've heard this in a lot of different areas. It's not just investment treaty arbitration, but in a lot of different areas where, if the parties are choosing the same people all the time, and it may not even be outright bias, it's just that they're used to, it's always easier and safer to go with the arbitrator that you already know and you've seen their cases and you've used them before. How do we change that though? I mean, is there maybe a better mechanism? And yes, there's been many pledges out there. There's been different statements made by different arbitral bodies. We've seen ICA, we've seen a lot of these different groups come out with different statements. Do you have any ideas of what you think might be a better way, or any creative solutions?
So I think there are clear limits to what pledges, important and laudable as they are, what pledges can achieve, because when it comes down to it, and if this is an important case for a party, which it often is, this tendency, this inclination to go for an arbitrator who's tried and tested, I think will still outweigh that pledge given to diversify the pool of arbitrators. So I'm not sure there are any magic bullets, safe short of moving away from party appointments altogether.
Yeah, I mean, there have been some proposals about moving away from party proposals. I've read scholarship where they've argued for just mandatory. If somebody is qualified, then why can't they just be automatically appointed? Do you have any views about those proposals, or whether or not that's a viable option?
So I'm sympathetic to some of these proposals. At the same time, I recognize that there is a risk that one of the few advantages these days from the perspective of investors and perhaps the parties to these disputes more generally might then disappear. That is, they feel that they have substantial input into the process on the basis of them being able to choose at least one arbitrator. Now that may or may not, I think the empirical evidence of that is mixed, contribute to how well the process works, whether the parties are prepared to accept the resulting award and comply with it. So I think that is a factor that one ought to bear in mind. But as I said, I think if one wants to take serious steps towards increasing diversity, I do think it's important to consider moving at least partly away from this institution of party-appointed arbitrators.
Yeah, especially if people are, they're qualified, they've gone through the training, they're, I think that it makes for a good case on some of these different proposals. Another thing that's come up, and just as we've been talking and thinking about your article and kind of the sociology and club-like atmosphere of some of these arbitral bodies, the question is, this movement, I've read quite a bit, and I'm sure you have as well, about the idea of moving toward more use of mediation because it's more voluntary, allows for more of a collaborative process. What are your views on that? Maybe is that part of the answer is moving toward more allowance for mediation in these investment, especially of course with the Singapore Convention. Do you see that as happening in the investment dispute area?
So I think that's, to me, that's quite a separate question from the composition of arbitral tribunals. I think there are some serious obstacles to many more of these disputes being mediated, or to use the expression that the ICSID Convention uses, to go to conciliation rather than arbitration. One is that if there is room for compromise, it's unlikely that that the parties would end up in arbitration. A large number, hard to know how high this percentage really is, but it's likely that at least 40% of all investment arbitrations settle, and it could be substantially more than that. And the disputes that we are left with are typically quite intractable. There is no real room for compromise, not clear whether there's really a solution that would satisfy at least partly both of the parties. So I think that's, in practice, is the most serious obstacle to mediation or conciliation playing a greater role. And it's quite remarkable that we've only had just over a dozen conciliations in the entire history of the ICSID Convention since the 1960s, compared to more than 650 arbitrations. So it's really, there's a huge difference in the order of magnitude when we compare arbitrations and conciliations.
That's interesting. Yeah, because I do know there are some proponents of mediation, and you're right, it doesn't change the composition of the arbitral panels, but it is just an issue about more of a collaborative and maybe giving the countries and giving parties more of an ability to be participatory in the actual dispute settlement process, of course, as opposed to dispute resolution, merely having a third party answer. But where you need a third party answer, sometimes arbitration is really the only way to end the dispute, as you note. I wonder though, kind of for you, next steps in research, because now you've been looking at the sociology of arbitrators, and from your article, you were reading a lot of other academics who looked at different empirical studies. Where do you see your next step as far as research?
So in terms of the composition of arbitral tribunals, I think there's something interesting that could be done on list procedures that are being used by arbitral tribunals, and to what extent these list procedures can help increase diversity. I know that's an area that some of the major arbitral institutions, particularly the PCA and ICSID have had an interest in for some time and have been experimenting with. I think there's interesting research that's done outside the law by economists and others on how list procedures can be used and what the different properties of these list procedures are and how they might produce better, more desirable outcomes, in this case, of an arbitral tribunal, a more diverse arbitral tribunal. So I think that's one area where I'd like to work on next.
Yeah, that's really interesting. I know Catherine Rogers and others have also been kind of looking into providing more information about arbitrators. I don't know if that's another idea that you think might be helpful.
Yes, I think that could be very helpful, and I really admire Professor Rogers' work on this. I think it's great to increase transparency about arbitrators. I think the jury is out whether that, what the net effect of that will be. It could lead to more diversity, could encourage parties to make bolder choices, because they feel that they have more information about relatively unknown individuals as potential arbitrators. But it could also, at least conceivably, have the opposite effect, that it could further entrench those arbitrators who are already appointed again and again.
Yeah, one of my concerns actually, I was talking with another professor who also has been working in this, Professor Sarah Rudolph Cole has an article that recently came out. And one of the things we talked about is sort of, I don't know if this is in Europe, if you have the same thing, but there's something called Rate My Professor. And what can happen is with these kind of anonymous ratings can actually hurt vulnerable groups sometimes. So, so you have to be careful with some kind of, evaluation systems if they're not careful. So I suppose there's always two sides to look at with most research as it is. Well, listen, great research, really interesting to think about how you can change the status quo, especially when it's been so entrenched for so many years. It's hard to do that. So I applaud your research and thank you for taking the time to talk with us today.
Thank you so much, Amy. Great pleasure speaking to you too.